Okay.
Okay, we're ready to get started.
So I'm going to go ahead and read our statement so we can jump into work. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. So do we have anybody that statement fits today? Does not look like it. So let's just jump in with Nicole. Oh, go ahead. Uh-oh.
I'm getting feedback. Brian, how do I fix this?
Mute the, go to your Chrome browser, the YouTube link, click mute on that. That might be what's going on.
Okay.
We don't hear the feedback. Or you can just close the YouTube screen that opened up.
Okay, maybe that works.
Is that better?
I think that's better. Okay, thank you. So I'll get started with I'm just going to summarize where we are now in terms of the track change opinion that I sent to you. So we all know that this is about one lawyer serving as both the guardian ad litem and the attorney advocate, and the conflict caused by Rule 3.7, which is a lawyer as a witness rule that provides that a lawyer can't serve as a necessary witness and also an advocate. So at our last meeting, you will recall that we discussed 3 different drafts of the opinion and decided that the second 2 drafts were not correct, and we were going to revert back to the initial draft that I prepared. So I did that, added all of that back in. What's different about this current version than the original version is that I included a reference to 2012 FEO 9, which is the opinion that a lawyer who's appointed in a custody or visitation case would have to point out to the court that they have a conflict under Rule 3.7 and can't testify, and ask the court to clarify the lawyer's role and not accept the appointment until the court clarifies the lawyer's role. So I incorporated that language into opinion number 1. And this is the opinion that says that, asks whether a lawyer can file a court report with a GAL court report and offer it into evidence if the lawyer is the one who drafted it. And so the answer is maybe. I didn't put a yes or no, so we need to talk about. Usually we like yes or no responses initially. But in this one, it is maybe, because it depends on whether or not the court allows the lawyer to serve as just the GAL, in which case, if so, then the lawyer can prepare the report, testify about his or her findings in that report. Inquiry number 2 addresses if the court declines the lawyer's request to limit the appointment to just one role, then can the lawyer call himself or herself as a witness and be subject to cross-examination? So again, I haven't put a yes or no in here, and it's just a reference to Rule 3.7. It explains what the purpose of Rule 3.7 is. And this is the part of the opinion that includes the caveats that in the interest of judicial efficiency, if the court can only or will only appoint one lawyer to serve both roles, then under these limited circumstances, the lawyer can testify, notwithstanding the fact that there's a conflict under Rule 3.7. And this is how we discussed dealing with the districts where there are not enough lawyers for the court to appoint 2 lawyers or 2 people to serve in the different roles, and in which case then they only have a choice of appointing just one lawyer. Inquiry number 3, may the conflict attorney who drafted a GAL report be called as a witness by the court or another party? And it just references see opinion number 2, because we talk about in opinion number 2 whether or not the lawyer can call him or herself as a witness. Inquiry number 4, ask about what the court's role is, and the answer is that it is outside the purview of the ethics committee to define what the court's role is, but then generally references the reader to opinion number 2. And then I eliminated inquiry number 5 that asks if the attorney may not file a GAL court report, or if the attorney may not testify, how may the attorney fulfill his statutory obligations and promote the best interests of the client. So I eliminated that inquiry because it's all been explained in the previous inquiries. So that is where we are right now. Dion?
You're muted, Dion.
I've done that to try to prevent the feedback. How do you guys feel about just starting from the opinion number 1 and working down in that fashion? And then seeing if we can give some definitive answers instead of maybes or non-answers, because I know that's what lawyers will want to see, if we can somehow either break them out into yes, if this is true, no, if this is true. I think at least get the yeses and nos on the things that we can. So for opinion number 1, I think that I think that it's wise to talk about the situation where, and I think that you did great in that, saying that if it's appointed purely to the GAL role and not the attorney advocate, when it's just the one role, which is what we wish that the judges would do, give one role to one lawyer and one role to another lawyer, yes, they can do the report and then maybe have a break in the paragraph and then go to another paragraph and say, however, when an attorney is appointed, there are situations where an attorney may be appointed to serve a dual role, that of both the GAL and the attorney advocate. And then break that analysis out. And then I don't know if maybe the first one would be if the attorney is just appointed to serve as a GAL advocate, then no, they would not do a report, certainly wouldn't be filed.
I agree. I mean, it occurs to me that the answer is yes, provided the court direct as follows. And so in some respects, we're putting this issue in the lap of the judge, because if the judge orders lawyers to serve the dual role, then they can do it. So I think the language with respect to the fact that the court is driving the determination makes the answers yes, provided. And if not, the court doesn't direct appropriately, then the answer is no.
And Nicole, I think most of the people that will actually be reading this opinion already work in this area, so they know background. But for those who don't, I don't know if there's any value of saying, generally speaking, or historically speaking, one attorney has served in both roles. However, and then going to what Gina said, a court must determine at the appointment stage, right? So when you serve as a guardian ad litem attorney advocate, you get appointed by the court. We get an order that appoints us. And so at that stage, the court needs to then tell us what role we are in. If it's going to be a dual role, great. Then you can put your report in, you can do all the things you're supposed to. If you're only going to be a GAL, then the answer to this question is yes, you can present the report and you can also testify. Dorothy and I've already talked about opinion 2. We'll get there in a minute. And whether or not we think that that's what should take place. But I do think that the way that you drafted it is accurate and I like it. I just wonder if, like Gina said, you start out with yes, if the court orders that you are in a dual role, right? Or if you are just a GAL, then you can put the report in. There's no maybe to it, because if that
Right.
is the case, then the court already told you that you can actually submit the report.
The other thing that I was wondering, because I hadn't been around long enough to know the answer to this, can we do what Sydney just said and say the court shall, or are we only in the business of directing what lawyers do? And so do we have to say the lawyer shall get clarification from the court? I don't know the answer to the
Right.
question. I just posed it.
Right. We
think it's the
can
latter.
only direct lawyers. We
Right, it's the
can't
latter.
direct the court.
So then maybe the answer is yes, provided the lawyer shall seek clarification from the court at the onset of the appointment as to the parameters of the role or whatever.
Jack, you probably just need to unmute and hop in. Feel like your hand's all raised.
So, well, yesterday, Brian and I were on another committee, but there was tons of people, and I typically just raise my hand like this, and I realized it wasn't showing up because there were, Brian, was there like 16 people on yesterday, and so I learned how to do the little computer one, so now I'm just showing off. No, but actually, you were going to my point. My point, or my question for someone who doesn't practice in this area, is the timing issue. In other words, one of the things that we've talked about numerous times is kind of making sure that one side isn't sandbagged evidentially. And so I just wanted to make sure that everyone knew well in advance of time. So this isn't happening in real time in the court. Oh, hey, guess what? They're going to be able to present the report, but you can't cross-examine them, or some weird hybrid situation where an attorney trying to represent one of the parties feels as though they never got a fair shake at figuring out what the basic evidentiary issues were in the court. So Gina, I think if I'm hearing you correctly, you were saying this stuff gets determined at an onset period that provides all the parties with enough heads up that they can do whatever they feel like they're going to need to do to represent their parties within the bounds of civil procedure and professional conduct and all that.
That's what I think it needs to be. Now, Sydney
Okay.
just raised an interesting issue, which is sometimes the appointment order just gets entered in the mail, and the lawyer doesn't have the opportunity prior to the appointment to say, I'll take this gig if.
Okay.
And so I think that's a problem I didn't know about.
That's
And
a
so she
great
said
point.
that.
That's a great point.
Yeah. So what typically will happen is that we get an appointment order in the mail. We don't even know about it. Sometimes the clerk will call and say, hey, will you accept this appointment? Then the judge signs off on an order. And the order says you are the guardian, you're the guardian ad litem attorney advocate. So in that role, you are supposed to be the advocate. You are not the volunteer.
Gotcha.
So in that role, technically, unless the court says it's inconvenient, then you as the attorney advocate shouldn't write a report and shouldn't actually testify. Now, what happens prior to a termination of parental rights hearing in some counties, but not in all, is that you have to have a pretrial hearing. Some counties have that on the same day. If you are asking as the guardian ad litem attorney advocate to then all of a sudden be a witness or to not be a witness, then the termination of parental rights hearing needs to be continued. They don't have to be 30 days apart. So
Okay.
procedurally, we have a problem because as it's practiced now in statute, you are appointed as the attorney advocate, period, end of story, full stop. You as the attorney, now that this has been brought up, need to ask the question, of which I'm telling you right now, 99.9% of attorneys don't know that this is an issue, need to ask the question, which role do you want me to be in, Judge?
Okay.
I have been doing that since this has been brought up, and the judges have been appointing attorneys to represent me or asking, what role do you want to be? You want to wear the attorney hat or the volunteer hat? And then they appoint another attorney. But I have made an issue of it. I have asked for a hearing and I have gotten the judge to rule on that. So it's clear for the record and for appellate purposes, because this is also the number one area of appeal, not the guardian ad litem part, but termination of parental rights actions are like the number one appealed issue, really, like that the Court of Appeals has to handle. So I don't know how you address that, but just procedurally, so you guys know background, that's how it would happen. And I'm concerned that if you have a pretrial hearing on the same day that you have a termination hearing, then the attorney has to decide what role they're going to be, or the court's going to have to decide it. And then you jump directly into a hearing. So if you say you're the volunteer, then there's no attorney to represent you in the hearing. Is that like, Dorothy, would you say that's the case?
I agree 100%. And the only other thing that, as you were talking, what I was thinking about to try to safeguard that, one, there's, like Sydney said, there's not, most attorneys are not going to do that extra step or not even think about that extra step. Like, I need to get them to tell me for sure which one it is without having known all this is going on. So the only other way that I can see to help with that issue is to somewhere on that form for the appointment of the guardian ad litem, it lists some kind of finding in there that the judge has to check off or whatever, and it's listed on there. But I know that's not on our purview, but.
Thank you, guys. That's very helpful. Thank you. Strike
Don't
that.
want to go too
It
far
helps
down.
for me to understand. It's just making things more convoluted now, though.
What,
And
what do
and
we-
it proves that Jack will never practice juvenile law, because he's like, what are you guys doing in that courtroom? I completely agree, Jack. Go ahead.
I mean, what is it that we do? I don't want to go too far down this, but it's just popped in. I mean, there is so much of, once we get the opinion there, the education of the lawyers and the practical way that this opinion can help people do the right ethical thing, which would be changing the forms or doing stuff like that. I mean, is there anything that we can do towards that end after the opinion comes out?
I think that we definitely issue some separate statements, you know what I mean? Like some marketing wise, blast emails, to individually to the bars, to the bar associations, you get what I'm saying? Just as much as we can to get the information out, and then hopefully the different bar, like we'll know, like I know I should, recommend that we have some kind of training or some special forum or something to invite Nicole to come talk to Durham County about this, this new thing or whatever, to educate people on it and let the folks over at the parents' attorney's office know. I mean, they'll know anyway that this is coming down, to include that in all the trainings and different things like that. But I think for sure we need to put the language in here, like what y'all talked about, that specifically puts the onus on the lawyer to make that in or get that clarification from the judge.
And Dion, there are lists for like the guardian ad litem program, DSS attorneys and parent attorneys. So we can actually have, and then we can talk to the School of Government. Sarah DePasquale does all of this work. She can go ahead and actually send out and summarize the new opinion so that it's aware. So there's a way for us to get the vast majority of people who practice in that courtroom to understand and to know that this is a major change. There's a huge overhaul in the juvenile code this year. So that has already been updated and provided to a lot of the lists. This will just be an additional one, not statutory, but at least a different opinion. Because Dorothy's right. The only honest that you can have is like, it needs to be on the DSS attorney or the petitioner attorney and the GAL who gets appointed. Mm-hmm. I suspect that what will happen is exactly what's happening now, which is the judges will just say you can do both roles and not even even do anything.
But it covers the attorney even if that appointment order, if there is an AOC form order, it will cover the attorney from doing something to injure himself or herself. If there is that block that puts it back on the judge, where the judge is making and has to make that determination, so that then this opinion can be useful in knowing which way that the attorney who has accepted that appointment should go with, the report or the testimony.
Absolutely.
Nicole and Brian, does somebody from the state bar go and speak at the district and superior court judges conferences or no?
Sometimes. Carmen has in the past, but really it's been about what a judge can do if a disciplinary matter comes before the court, or if the court wants to initiate a disciplinary matter. It's been really kind of restricted to that, and informing them of the resource that the bar can be to judges. But we don't have like a regular appearance. I think we'll usually have an officer that goes down there and perhaps just sends greetings and all that, we might get 5 minutes in those regards. But we don't have some sort of regular appearance, but would be happy to if there's, if there's a desire for us to show up.
Because my guess
But-
is it never occurs to a judge that they're putting a target on the back of a lawyer. They're just trying to get, they're interested in judicial economy. They're not thinking about the predicament they're putting a lawyer in if they appoint her to do a job without clarification on this. So it'd be nice if we could help them understand they actually need to take a minute and check an extra box in the appointment, and hopefully the new appointment order that says you can serve the dual role and I'm ordering you to.
Well, Gina, the way that can happen is that what Sydney was talking about with Sarah DePasquale, she does a judges conference, and it's specifically for the judges in A&D court, and she breaks down several different things. And so that could be, with her knowledge of this going on, she would include something like this in those trainings specifically for those judges to make sure they're educated on that.
And she's an AOC person?
She's at the School of Government.
Okay, got it.
We separately have to talk to the AOC person. They have an entire commission that goes over the forms and has to go through 5 billion steps before anything's improved. So that's like a act of Congress. That doesn't mean we don't start now, so it can happen 12 years from now. But I do think that we should talk to someone at AOC to go ahead and see whether or not they're willing to put the checkbox on there. But Sarah can at least educate the judges in the meantime.
Yeah.
And they could probably just write and modify, like write on the order as both dual role or GAL. I mean,
Absolutely.
shouldn't be that
And
hard.
they trust her 100%. Trust me. They look forward to it. I mean, because I've actually been called, I mean, I think, Sydney, you have too, to go speak at those trainings specifically for the judges, to teach the judges about different things. So
I'll just offer, as far as this opinion, this opinion and the ethics committee is going to be focused on lawyers and what lawyers' obligations are. And so I think you can have some language that basically, until that is there, until that's kind of a typical form or just practice from the bench, that it can put it on the lawyer to clarify. You can have an obligation to say, that a lawyer does have an obligation to clarify their role, that essentially, if they're only appointed in the sole GAL role, then that's one answer. But if you're appointed in the dual role, then you can only proceed if you raise the ethical concerns or inform the court of the potential ethical considerations, and that the court concludes the attorney may proceed in this dual role. I think that is what kind of absolves the attorney of the ethical concerns that we've identified here. But that way it stays focused on the lawyer, which, the rules are going to be focused on the lawyer. It puts it on the attorney.
No, but I want to make it as, I'm
Yes.
thinking next steps to try to make it as, to get rid of all the landmines, because
Yes. Totally.
and you kind of have to have the judge's cooperation, so the judge knows that this is coming down the pipe, so they won't think that the attorney's being belligerent making this request every time. So I think that it's, just practically speaking, it's important if we can get the word out, but I know that's not our job. But so does anybody have anything more to say about opinion 1 that could help, Nicole? Are we ready to go into number 2? Because I can see Sydney and Dorothy getting ready to strike. So why don't y'all go ahead from there?
yeah, I think we just need to be definitive here with no. Yes. I know we need more, but we definitely need to start off with no.
I think that Dorothy and I's issue is that we don't think that it should just be for judicial economy's sake because you can't find enough attorneys, right?
Exactly.
Like, we just don't like the answer. That doesn't mean that it can't be the answer. I just fundamentally think that we shouldn't be placed in a position in which, if we are dealing with our code of ethics and our professional responsibility to a client, that we should not start changing the rules simply because it's inconvenient to not find 2 people in a courtroom. I mean, but Nicole has pointed out that the court has dual jurisdiction. And if they give permission to an attorney to say you can do this, then the attorney is covered and wouldn't be violating a rule of professional conduct. Is that correct, Nicole or Brian?
Correct. So maybe I could say no, unless the lawyer has already asked the court to clarify and the court has stated that the lawyer will play. I mean, I'll clean that up, but the lawyer will serve dual roles. Is that better?
So
Can
that
you
was
say
my
that
thought.
again?
Yeah.
Sorry, can you say it again?
So the answer would be no, unless the lawyer has already asked the court to identify or clarify the lawyer's role, and the court has determined that the lawyer will serve the dual role. So basically, the lawyer, like we said in opinion number 1, the lawyer has to address the conflict issue with the court that the lawyer can't testify. But if the court, after hearing all that, says, so what, I don't care, you're going to be dual role, then only then can the lawyer call himself as a witness.
And I think that we need to use the word order, unless the court orders the lawyer to serve the dual role at the appointment conference or at the onset of the appointment. Back to protecting against Jack's problem is we can't have people being confused about what the roles are at the time of the trial when we're trying to terminate parental rights, for God's sakes. It has to be clear from the get-go that this is what could happen, because otherwise we got violent due process problems.
Gina, I think you and I are just tracking parallel throughout this whole thing, because while we were, at the end of 1, I didn't want to belabor the point, but, I was thinking to myself, this kind of stuff happens all the time where there is not a particular format, but that I will craft something, and in the caption, just call it order of the court, because a judge makes some decision that, is like slightly anomalous, and you just can. So I could totally see if I were the attorney and I was trying to make sure that I was covered in this thing, I'd have in the file something that I just called order of the court and a 1 or 2 sentence paragraph that said, now blah 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 blah. The court orders that Jack Lloyd is in X role in this case, blah blah blah. Sign, date, judge. It's in the file. I'm covered, and yes.
I know I'm probably making this even more convoluted, because this just occurred to me that this says, if the court declines the attorney's request to limit the appointment to 1 role, the North Carolina Rules of Professional Conduct, specifically Rule 3.7, permits the attorney to call him or herself as a witness and be subject to cross-examination. When really what can happen is they don't even have to call themselves. Somebody else can call them. And so is there some way that we need to capture that? That's number 1 I was thinking about. And then 2, is there a way that we can include some language? Now I'm thinking out loud right now, y'all. I know we can't tell judges what to do necessarily. Well, we can, but they might not listen. But shouldn't it be some avenue that the judge, the person, if they just really, the judge says, I'm appointing you in this dual role. And if that particular lawyer just says, I feel uncomfortable doing this, that they have to move them on to somebody else, that they can't just order that person to just be that. Am I making sense? Y'all get what I'm saying? Because I can see, like me personally, I would be one of those. I can see me being one of those persons. And I'm in court and the judge is like, Dorothy, I know how you are on these kind of cases. I need you to do this particular case. And I'm like, well, I need you to tell me, can you limit my role? I need to be one or the other. And they're like, no, you're going to be both. And I'm like, I just feel uncomfortable with that, because I know for me, I would feel uncomfortable being called as a witness and being subject to cross-examination and a report. You get what I'm saying, and all of that. And I just don't want to do that. Put myself in that.
You always have that authority to decline an appointment, though.
Not necessarily.
Y'all don't?
No.
Really?
Really.
Oh my God.
And that's what made me think of
terrible.
this. That's what made me think of this. And I could see me being that one that if I was put in this predicament, I would never call myself. But that doesn't mean that I won't get called.
So you're
Somebody else
saying
can call me.
a judge can order you to take on a role that you contend violates your responsibilities to the rules of professional conduct? Is that what y'all telling me?
Well,
Wow.
Now
That's
let's be
rough.
yes
let's
and
be clear,
no,
Gina.
because
They don't think this is the first time that this is actually being explored. So it's not been an issue, but for this inquiry, that most of the judges think that this is even a violation. The standard practice is the dual role, period, end of story. That is what has been happening for decades, right? Since this statute has been in place, that has been what has actually occurred in all of these private cases, is that you are one attorney acting in a dual role. For the past 16 years, if I'm appointed, we've been acting in a dual role, and the judge just orders it. I think the question, and to your point, Dorothy, with regards to the first question is, I think we should permit the attorney to call himself and just say specifically rule 3.7, Nicole, and it should say something like, does it permit an attorney to testify or become a witness for a cross-examination, regardless of whether or not we call ourselves, because I never call myself as the guardian ad litem. I get called by usually the person who's happy with my recommendation. And so that is the person that then starts cross-examining me. But that's I guess the first question, or at least addressing Dorothy's concern. The opinion in and of itself, I think, is written like is fine. I just think that fundamentally, going back to Gina and Jack's original issue, is that the nature of that courtroom, the decision needs to be made early on. And usually it's not. And I think that the burden needs to be on the attorney to bring it up, because the only way that we can't control what the judges are going to do, but it should be the burden of the attorney very early on to determine what role they are before they take the role on. Like, you can get appointed, but we need to have it in writing in some order to protect us for professional conduct reasons, of which I've been doing since this has been brought up. The judges are always appointing me, and then I'm asking for them to decide what my role is and to appoint another attorney. And other counties are not necessarily doing that, and that's their right. But I do think that we need to put the burden on the attorney to say it's your responsibility to make sure that this is very clear before you move forward, because it puts us in a really bad ethical bind.
And Gina, that's what Sydney just described is exactly what happens, because the judges know who they can trust and who everybody is going to appreciate their being thorough in their reports and in their investigation and all of that. And that's why Sydney is the one that's being called upon all the time to be put in this role. So it is very limited number of people too. That's the other thing. So when you're saying, can they just move on? That's, in their mind, it's like, no, Sydney is the one for this every time. And like you said, I'll be the rogue one too. Like, okay, well, the way I'll leave it at, I'm not gonna call myself ever. But then I'm called by somebody else. And you are able to edit that, right? Because I see we had that first part, but okay. Because the last paragraph does deal with that portion of it. The attorney is identified as the witness part. So the answers does include all of that.
Yeah, I'll just move the language around. I'll just move it up.
Well, thank you all for sharing that particular point. It certainly opens my eyes to some of the, and helps me better contextualize and understand some of the issues you all have brought up over the time. It's, wow, I had no idea. Like Gina said, that's very eye-opening. Thank you.
Any other comments about inquiry number 2 and opinion number 2? Okay, and then inquiry number 3, I think, is sort of what Dorothy was talking about, right? Where the guardian ad litem is within the dual role is called by the other side or by one of the other parties, right?
But I think if we're going to edit number 2 to include just being a witness, then, to testify, then We don't really need 3.
Right, right.
That's what I was gonna say. We'll just eliminate 3.
Yes.
Yeah.
I'm channeling my inner Sydney right now, because when I read number 4, I had a really like facetious thought.
Okay.
What is your role?
Sh-
Do your
share it.
job.
Do your job.
Right,
Follow the statute.
right.
Do your job. Make some hard decisions. You're the judge.
Right.
You get paid for it.
Take a stance.
Can't tell you what your role is. Your role's already in statute.
Exactly.
Read the statute.
Wow.
So just leave it as it is.
Yeah.
Yes.
Refer them to the statute. And we
Or I
can't tell
could
the court
put-
what to do.
I can put C, Sydney and Dorothy for further.
Right. Please tell them that. That'd be fun.
Yeah, I think that is an appropriate, your response is perfect, Nicole. Minus my snark, it is
I
perfect.
mean, do we, I guess we'll see how it looks in the response or in the earlier inquiries, but, emphasizing that requirement on, the attorney to make this inquiry about the, what role you're in. Is that going to be the way it's going to look? Is it going to jump out to the attorney reading this that, oh, this is something special that I'm going to need to do? I just don't want it to get sucked up in it where they don't see, I've got something that I have to do. The judge might not do this themselves.
Well, and I also would say that DSS, so in this case, it probably isn't going to be a DSS attorney, even though there are some conflict DSS cases where DSS is going to be involved in a private TPR and they have conflict attorneys outside without volunteers. This will affect them. There are actually a number of counties that have conflict DSS attorneys. This is going to upend their entire way of practice. I will not name counties on here, but one in particular that I practice in a decent amount has conflict attorneys, and they are the dual role. So I think that it is incumbent upon any attorney in that courtroom to bring it to the judge's attention, even if it's not the attorney who got appointed as the GAL. The GAL attorney should ask, but that doesn't absolve the other attorneys in the courtroom from being able to make sure that we're actually following procedure. And this happens all the time. I mean, there are some attorneys that are better than others, and we have attorneys that interject and make motions that somebody else should have made or brought to the judge's attention simply because they know the law better in this area. And so I do think that it absolutely needs to be incumbent upon the person who's appointed, but I don't think that it absolves any of the other actors, being the respondent attorneys and or being the actual petitioning attorney, to be able to draw to the judge's attention that there's an issue with regards to a dual role. This actually happened, Dorothy, I don't know how many years ago, when we finally got the new statute for guardian ad litem, Rule 17 guardian ad litems for parents.
Yep.
Even though the parent attorney was supposed to ask and make the motion for the Rule 17 guardian ad litem, DSS actually took that role over and oftentimes was the one that was making the motion. And so I think that in this particular case, we also need to, in the education piece, bring it to the attention of the petitioners, be it DSS and be it the respondent parents, that this needs to be addressed not only by the person appointed, but that if it isn't addressed, that they bring it to the court's attention. Not
And
trying to complicate the law.
Even further, there are judges now who take on that role of the inquiry of the guardian ad litem. The point for the parent. Which is, whole nother soapbox.
So it's clear that the rules of civil procedure just don't apply. Is that it? Is that what y'all are telling us?
They're loose.
Very.
The
And
rules
it's
of
crazy
evidence are
because
not
it's
strictly adhered to
right.
in certain
And there are
hearings.
different stages where they are applied strictly or supposed to be, and then other phases where they're not. And those can happen at the same time. And you gotta it's
As I had a judge tell me one time that hearsay doesn't apply in hearings, it only applies in trial.
Wow. That's a new one. I'm like, wow.
Or when you object to hearsay and the judge says, Ms. Batch, please stop objecting. It's just not that important. I'm sorry, what? Say it a little louder in the mic. I'm appealing this. But yeah, that happens. So welcome to our court. Juvenile court's the best.
Mm.
So are
We're
you
not winning
asking
anyone
me
over,
to-
Dorothy, by the way, who's listening to
know.
this live stream. No one will come into our courtroom.
I know. But I think as far as what we have, I think is good.
Agreed.
I think the onus more, but Gina, going back to your point about no, Dion, about whether this stands out. I think where it's going to really stand out is the communication of this is where it's really going to, get the attention of everybody.
Well, I think it's really, really important. And I'm not just saying that because we're on the committee and want to pat ourselves in the back, but this is very, very important. This is, this is a huge change. And I think, and we're already having trouble with recruitment of folks to do this kind of work. I want them to know crystal clear what they're expecting, and they aren't running into ethical problems, and that they know exactly what to do, or at least as close to exact as we can, so that we are not running away people doing this very important work. If there is any consideration of folks who might be more seasoned or just want to do this as their active public service, I don't want them to think, well, I could ruin my whole career because I'm going to slam into a horrible ethical ruling, or an ethical dilemma, not an ethical ruling, that we haven't thought through. So I think that if we get this out and we get it and somehow just in our own little worlds, push it out to folks, I think it'll help calm them down a little bit, and may help some with recruitment. But what would you say, Nicole, would be our next steps after you make these changes? Are we going to need to meet again, or are we going to try to do it by email, or what?
Ideally, another meeting, but I don't know that we may run into more scheduling problems with that. So why don't we try to, why don't I just send it out by email? Is that okay? And then each of you respond just to me. We can't do a reply all because then we're holding a meeting. So if you just respond to me, and then based on your responses, then maybe we can decide whether or not we need to get together again to have another meeting, which means I'll need you to respond pretty quickly.
That was directed to Sydney Batch. Hey, Sydney, it's called email.
So please don't wait until the day before the ethics committee to say, hey, Nicole, I don't like this.
But we both over here like
who's she talking to? Oh, I know, it's me. I know. I'll be better. I promise.
If that happens, I'm just going to drive over to Sydney's house and be like, Sydney, fill out the doodle. Fill it out.
I'm always the last person to do the doodle, which is why Nicole's on vacation and hanging out with us. So anyone who's live streaming it, Nicole is really she is the hero. She is the MVP of this entire meeting today.
Here.
Ditto. Yep. For sure, Nicole, that was some heavy lifting, and you did it.
Yeah.
Thank you.
And y'all allowed us to get on our soapbox and get off of it, too.
And didn't kick us off. It's so nice.
Right.
You guys are the best. We won't be on any other committees. Don't worry, Dorothy. Like, no, please. Not signing up for that subcommittee with her.
But Brian over there like, don't speak too soon, Dorothy.
Well, do we have any other business we want to discuss? I just want to tell y'all, I really have enjoyed working on this because when I first started, I thought that the issue, I think that it was sort of, I knew that this dual role issue was there, but I hadn't really thought about it. I just knew that it just seemed like it was happening. And I remember thinking to myself, why are the attorneys getting up and testifying? Because I wasn't in A&D court and it wasn't happening much in domestic court. So I thought that was a little weird, but I thought there's got to be some workaround. There's something in there that's already set. This has already been handled. This must be allowed, even though it doesn't seem right. So then digging down into this and recognizing that it just was happening and it had never been vetted really before, I just feel really happy that we've given it a lot of thought.
Awesome.
Absolutely.
So way to go, guys.
Yeah. Thanks, everybody, and happy Thanksgiving.
Yes, happy Thanksgiving.
Yep.
Happy Thanksgiving, everybody. Thank you.
Thanks,
All right, y'all
everybody.
have a good
Bye-bye.
one.
Thanks.
Bye-bye.
Bye, guys.
Bye.